more than that. Under State versus Williams, 93 New Jersey 39, 63, 1983, to overcome the burden that you have as it relates to this particular issue, you have to have some affirmative information. What you have is speculation. So if you only have speculation, that you're putting these things together and saying, okay, well, when you look at these things, because it smells bad, it must be bad. That's not the standard. So even when you go to the cumulative errors point, your point 4, if the underlying facts are not substantiated and they're only speculation, they can't be considered for the cumulative error. And I'm sure the case law is clear. I can go find that case for you too. But the reality is that that's what I'm told not to do. So from where you're coming from, I get your point. I get what you're saying, but there's a reason why I think, based upon the case law and Feaster, why it's stated the way that it is. If you don't have any proof to overcome the burden, then the lack of proof under these circumstances, the no juror affidavit, the no post-verdict statement, the no juror note, the no communication of any kind to the juror, that's zero affirmation of rebuttable evidence in the record to support what you're saying. So I understand where you're coming from. I'm not going to belabor the point. That was my question that I had for you as it relates to that particular issue, and I appreciate that. My next question for you. Let's talk about the issues, some of the other issues that happen in front of the jury. Okay. In each in-jury intervention, your identification as you identify in these circumstances that the court either sua sponte formed its own objection to these questions. When I reviewed the record, those interventions did not arise in a vacuum. During Detective Brady's cross-examination, the witness had already answered the point multiple times. During Detective Miglerisi's testimony, the question called for the information outside the witness's personal knowledge. And with respect to Detective Bassinger, the record does not appear to reflect a wholly sua sponte intervention as your brief suggests, because if you look back on the record and you looked at the video at the time, and that was your witness, so you may not have seen it, out of fairness to you, that the prosecutor was standing up and his arms were in the air, and I sustained the objection. So it was, the prosecutor was standing up and I was responding, but was saying that. So am I correct in saying that as to these instances that we're talking about, these 3, the defense is not really challenging the validity of the rulings themselves. However, what you're challenging is the way it happened, the procedure in which it happened, meaning that I stepped in before an actual objection occurred. Am I correct?
That's my understanding of the argument, yes.
Okay. So that would really go to, tell me if I'm wrong, because that's why I'm trying to create the record here, is that, so that would really go to the demeanor of me in front of the jury. That's what you're talking about?
Well, certainly that, that it also wasn't a situation where during the course of the trial, I mean, obviously the defense raised objections to questions that the state was asking, and sometimes those were overruled, sometimes they were sustained. Your Honor made, decisions in that regard, but it was only the defense that had questions sustained in terms of the court's findings prior to, and sometimes in the absence of the state raising any objection. And so the perspective we have on that is not just that, yes, that was the court inserting itself into the proceedings, but that it was kind of a lopsided way of doing it, to the extent that it is not something that happened where the state would ask a question. And I think sometimes they would ask outright objectionable questions and, you know, but Your Honor would not sustain its own court's own objection, except in instances when the questioning was being done by the defense. And so I think that that's important to bear in mind. And obviously, Your Honor is extremely well versed in criminal law. So, you know, it was also clear that sometimes the state was had objectionable questions. So that's why we thought that was noteworthy.
Okay, so, and I understand where you're coming from. However, so that we're on the same page here, is that when I'm doing the analysis in the opinion for this motion for a new trial, I'm going to be addressing it as to the form of my demeanor, because there is no objection to the underlying validity of the court's ruling. So we're dealing with my demeanor. So I'm going back to the analysis under Allen versus Alabama and some of the cases there. And I'm going to look at, so that you know exactly what I'm doing, that I'm going to look at those interactions and how they actually occurred and what was going on during the course of that, those particular questions. Because when you do that, there are times where I say to move on and people are not moving on, meaning the defense. And then that creates another sustained objection that may not have been objected to right in that question. But when you look at it in the context of an objection did occur, I sustained it. And then counsel decided to do the same thing, even though I've already told her that the objection was sustained. So that's where I will draw that balance of looking at my demeanor as it relates to the conduct that was happening in front of me. And I believe, I think you'll agree with me, under Rule 611A, that I have to make a determination and I have to keep the trial moving in a purposeful way. And if people are not responding to the court's decisions, then the court may have to do something about that. Do you disagree with that?
I think you have wide latitude there.
Okay.
But
You think I went too far?
yes. I mean, in some respects.
Mhm.
In some respects I do, you know, but I.
Which one?
Well, I think with Detective Brady, I thought that my recollection of it was that it was a bit, I think it was pushed a bit far between the court and Ms. Mastalone. I think that she was asking questions that ultimately were not objectionable. I think they would have led to admissible testimony. I think Your Honor had for whatever reason, with the personalities involved with this case, that by that point in time, I think Your Honor did. To me, it seemed kind of visibly lose patience with Ms. Mastalone during that cross-examination. And that to me seemed to be beyond the kind of what we would generally think of as within the 611 confines of the court's latitude to control the proceedings.
Okay.
And it's not like I'm saying that this was a perpetual issue, of course, of course, with the entire trial, but I'm saying in the moments that it did happen, I think it was very clear, it was very noticeable, at least to me, it was palpable in the room as it was happening. So that would be one such instance.
Okay, so even though that there was nothing written in your brief that, because now you're, based on what you just said, is that you think that these questions were okay. That was not argued within your brief. So what you're saying now is that her questions that she asked of Detective Sergeant Brady, or just Sergeant Brady, I should say, you're saying that they were appropriate and that the court's intervention was, one, unnecessary legally, but two, as a demeanor issue, that it's your position based upon your observation of the court that the court went too far. Am I correct? Just so that it's clear for the record.
That's what I'm saying.
All right. So I'll look at that in the way that you're stating it. I'm not sure that I necessarily agree under those circumstances when you look at the entire record and you look at the interaction between Brady and Miss Mastalone. But we'll take a look at it, and I'll definitely make sure that that's all part of the ultimate decision. Let's talk for a minute about, this is my last question as it relates to just the first point. Your brief relies heavily on State versus Guido, 40 New Jersey, 191, 1963. And I want to make sure that I understand the comparison that you're drawing. In Guido, the trial court publicly accused defense counsel of altering an expert report in front of the jury during open proceedings. And then the prosecutor reinforced that accusation in summation. Those are the two features that made Guido what it was, a public accusation made by the fact finder, amplified by the state. The day 17 exchange here, the one that you describe as the most inflammatory moment in the trial, the jury was not present. And the state's summation made no reference to the sustained discovery violation. So help me understand the defense's position as to why Guido is appropriate under these circumstances to draw an analogy to, considering that they're two completely different things. One happened in front of the jury, one happened outside the presence of the jury, which is what we have here.
So I understand Your Honor's point in that regard. I don't really have any commentary on that matter outside of
What's in the brief? All right, I'll leave it alone. All right, let's talk about some of the questions, some of the things that came up in the prosecutor's summation, because I want to make sure that I flesh it out from the defense's perspective, because there was the majority of your brief talks about this particular issue. So before turning to the individual remarks that are challenged in point 2, the defense's brief identifies a number of alleged improprieties in the state's summation, but only a limited number drew contemporaneous objections at trial. As to the remainder, including the DVR comments, the state of mind passages, the references, now characterized as improper, and the financial arguments, no objections were made. When I look at State versus Frost, the absence of a contemporaneous objection is significant, both because it suggests the remarks were not perceived as prejudicial at the time, and because it deprives the court of the opportunity to take a curative action when any problem could have been addressed. How does point 2 overcome Frost when so many of the remarks now relied upon were not objected to?
Yeah, so that's correct. And many of these were not objected to. I would point out that the closing of the state was over 6 hours long. It was accompanied by an extremely comprehensive PowerPoint presentation. In that period of 6 hours, I wouldn't say that it was very redundant at all. I mean, it was lengthy, but it was not largely repetitive. there was a lot of information provided over the course of the summation. And, you know, part of, you know, defense practice is a determination as to how often and how strenuously one should object, because obviously some things are objectionable that, and you may not want to draw attention to them for the jury if they're not already focused on it. You may not want to be seen to be unduly objecting. And certainly over the course of a prosecutor's summation, the decision of whether to object at a given point of time, you know, these are things that can be debated. The case law, as Your Honor mentioned, is clear that the lack of objection is an indication perhaps that the defense did not have a problem with what was being stated at the time. I can say that that is, from my perspective, not the case, that at times the lack of objection was rooted not in a feeling that it was unproblematic, more so in a feeling that it perhaps would unduly draw attention to a matter that if the jury might not already be focused on it, or some of them might not already be focused on it, better to let sleeping dogs lie, as it were.
So I understand that. I understand where you're coming from. But as you also know, when you talk about the 6 hours of Mr. Decker's summation, it was over the course of 2 days. So at the end of the first day, when the jurors were let go for the day, I ask, anybody have anything they need to put on the record? Nobody says anything. That's outside the presence of the jury. Any objection that needed to be made could have been made at that point in time. A motion for a mistrial could have been made outside the presence of the jury at that time. None of that occurs. So the balancing that you're talking about, which I respect and understand, we have a natural break to be able to make those objections, and they weren't done. Let's take it a step further. You have all night to think about it. The next morning, we come back in the next morning. You have the opportunity before we start to put something on the record, make any objections that you want. They were not made. So, and a mistrial was not requested. So under these circumstances, it leaves the court to believe that at the time that the summation was going on, that there weren't other objections. And on top of that is that the court, during the course of the summation, did, if we recall, have a problem with something that Mr. Decker said that was not objected to by either one of you, that I thought may have infringed on the defendant's Fifth Amendment right. I brought you to sidebar. We had a discussion about it. I gave you the opportunity to think about it overnight, because I was going to charge it right then and there. You told me you wanted to think about it. Ms. Massalone came up the next morning and said, Judge, we want to leave it alone. You can handle it with the charge at the end. So I understand where you're coming from. I guess my concern is that it doesn't look good in your record that you're saying you didn't want to over object during the course of a summation because you didn't want to look like you were fearing anything. But at the same point in time, you had times outside the record and you still didn't do it. That's the concern that I have when I'm evaluating this argument that you're making. That's why I wanted to give you the opportunity if there's something else that I may have missed other than what you just said.
Well, procedurally, I don't think that there would be, because what you're, can't contest anything that you're saying as far as we never asked for a mistrial. That's true. In terms of placing things on the record at the conclusion of the state's summation, that did not happen as far as objections for the record. I think that regardless of that, and that's gonna be a consideration for any reviewing court. But I don't think that there's anything I can say about that now, other than that those are facts. And what I think we're trying to put forward in our submission to the court is that there was such a volume of these incidences that happened over the course of what was cumulatively a 6-hour presentation by the state that, you know, regardless at points of whether we should have objected to a particular instance of this taking place, in the aggregate, it's something that perhaps the court had a you know, as the you know, person presiding over the proceedings, to in the aggregate make sure the jury was aware that, you know, of such things as the fact that just because Mr. Decker is saying that inserting the idea of, you know, perhaps, for example, Paul Caneiro's testimony into the record, not literally saying that, not explicitly saying Paul didn't testify, but relating to instances of like, well, what was Paul thinking as he was driving home? Only God knows what's being said in that moment between Paul, Jesse, and Sophia. If there's an explanation for why that camera was shut off, I'm not aware of it. You know, I mean, but all these things, aside from being burden shifting, I think are just instances of the state basically, in some respect, they're highlighting to the jury, you know who knows those things? Paul Caneiro, right? And you know who didn't testify is Paul Caneiro. And so I think that to do that, not just in a single instance, I think the importance of what we're trying to present in the submission is that in the aggregate, that happening over and over again in these different facets had the ability to come into the jurors' minds in an impermissible way.
All right, let's go to that for a minute. Your brief relies on State versus Angle for the DVR no explanation argument. But Angle itself relied on State versus Gosser, which held no explanation is no more than fair comment on absent evidence. Did the state's summation ever directly invite the jury to ask why your client hadn't testified as it did in Angle? Did it ever go that far?
No, I mean, Mr. Decker's never said specifically that Paul Caneiro didn't testify, nor did I think he invite people to speculate as to why that didn't happen specifically.